All right, it's time to look into what's trending in employment law. Lawyer, you're on the clock.
All right, so the first one I want to talk about, Phil, we've kind of been following things here with this Muldrow versus the City of St. Louis case, where the U.S. Supreme Court expanded what constitutes an adverse employment action under the anti-discrimination laws. And just kind of following on to that, yesterday, the Eighth Circuit Court of Appeals reopened a Black social workers lawsuit. In that case, he alleged that he received an unfavorable performance review because he had asked for a new stand-up desk to work remotely in his wheelchair. So he was working remotely. He's in a wheelchair. He made a request for a stand-up desk so that he could more easily fit his wheelchair underneath that. The appeals court said that on remand, the court needs to consider whether the employee did enough to show that he faced an adverse employment action in light of the Supreme Court's ruling this past April in that Muldrow case. So interesting to see how this starts to play out. In November 2020, the plaintiff in the case had asked the employer to provide a standing desk so he could work remotely in his wheelchair. That request was denied, and the employer said that when he made the request that the desk was really nothing more than a convenience or a choice. The employee then complained to the ADA coordinator supervisor. And then after that, the employee who made the request was also, he complained that a female colleague had accused him of conducting an onboarding training in his native language of Somali. And the managers dismissed the accusation as false, but then the same coworker made another complaint about him again in March of 2021. During the March of 2021 performance review, the supervisor told the employee that he needed to improve his communication skills. He was also subjected to a disciplinary investigation in which it was recommended that he receive coaching. And so the Eighth Circuit Court of Appeals said that they need to consider under Muldrow whether that performance review and the coaching are adverse employment actions under Title VII. My hunch is that they're going to ultimately conclude that these were not adverse employment actions, but I don't know all of the facts of the case. But again, we're just kind of following the Muldrow case here.
I just feel like we're out of control, Burt. I know it's Halloween, and I mean, there's all kinds of things going on here, but I mean, it feels like we're way out of control with all these. I mean, where's the reasonableness in the way that people behave on both sides here? Whatever might be taking place, I have no idea, but it seems like with some simple conversation and reasonableness, these things get resolved. But I'm sure there's something more going on beyond being reasonable here.
I have no doubt. So we'll continue to keep an eye on this one, see how it plays out on remand at the trial court level, the district court, and whether the district court concludes that these were adverse employment actions. I can promise you one thing, that no matter what the district court concludes, unless the case settles some way, somehow, it's going to be back on appeal to the Eighth Circuit, whatever this district court judge decides.
Well, stay tuned, and we will keep you up to date. We've been following this for a while now, so stay tuned, and lawyer Burt Garland here will keep you up to date. What else you got, Burt?
All right. We had a great program, Phil, yesterday that we did yesterday out at AIM on exempt versus non-exempt, and we talked about the top 10 mistakes that employers make in the wage and hour area. And one of those top 10 mistakes is not properly compensating employees for time that they spend donning and doffing protective gear or waiting in line for security screenings, etc.
And the activities prior to work or that are adjacent to your work responsibilities. Yeah,
that's exactly right. And on the flip side, time spent at the end of the day to wrap up before you clock out or before you can finish the work for the day. So just wanted to bring this to our viewers' attention. Amazon got hit with a proposed 10,000 member class action in New York federal court in the last couple days. In that suit, They're alleging that that it took between 5 and 10 minutes to walk from the entry of the warehouse to the time clock. Pre-shift activities increased to 30 minutes per employee when the company implemented COVID-19 screenings. They also say that the company did not pay them for their security screenings that they were required to undergo before leaving the warehouse. And so this is going to be a large case up in New York. I'm not sure which way the court will go on this. And in fact, I can't comment one way or the other on it, but just beware that this lawsuit was filed seeking to represent more than 10,000 workers in what in essence is what we would classify as a donning and doffing case. The time spent in security screenings and then the time spent walking to their workstations after they were required to go clock in at a different location.
Yeah, well, that's going to be an interesting one to follow for sure. And I know you'll have to be careful and what you comment and say on that. But, you know, I think about jobs that I've had over the years and that travel time, basically once you're on company premise to your workstation after you've donned your equipment or gathered your gear or you clocked in, was always paid by the companies that I worked with. So I'll be curious to see how this one vets out. And that's gonna, what you said, 10,000 workers?
10,000, and not only
Over
that.
how many years?
Yeah, I think over because it's under New York state law that the claims are being brought. I think that the statute of limitations goes back like 6 or 7 years, so it could be a huge
Oh
class.
my goodness. Yeah, you're talking possibly millions.
I would say.
Yeah, possibly millions here. All right. Well, we'll keep an eye on that as well. That's that one's really timely with yesterday's program, which by the way was fantastic. For anyone that missed that program, we do have it available we do have it available on demand. And you can reach out to your advisor here at AIM, or you may send us a note online there and fill out a form. We'll be able to help you get that program set up for you. But it was a fantastic program. I think you and Samuel did a wonderful job. The reviews were amazing. Just amazing. You hit the mark, I think, on all fronts there.
Great. Well, I think we had about close to 40 people in attendance live and another 80 plus online for the program. So it was very well attended.
It was great. Yep. What else you have, Burt?
All right, this one will segue us nicely into our topic today. I just want to bring to people's attention that, we've talked a lot about the gig economy and how most states and even the federal government, depending on which party is in power, wants to try to convert gig economy workers into employees. And because if they're employees, they can do things like unionize, and then they're entitled to federal benefits and federal protections like health care under the Affordable Care Act, and then protections under Title VII, FMLA, etc. Well, the voters in Massachusetts are taking a different approach to this issue. And next week, they're going to decide whether Uber and Lyft drivers can form a union and collectively negotiate their pay and working conditions, even though they're still independent contractors. So just a very different approach. They're not even trying to convert them into employees. They're just trying to give them the legal right to unionize as independent contractors. And it's kind of a similar mechanism to the way bargaining might work in a workplace sector in Europe. And so
that's exactly what I was thinking of. Exactly what I was thinking of. Yeah.
They're trying that methodology up in Massachusetts. Massachusetts has more than 84,000 registered rideshare drivers. And both of those companies, Uber and Lyft, deem their drivers to be independent contractors instead of employees. And this would really shake up the landscape. And by the way, if it passes in Massachusetts and is able to withstand scrutiny in the court system, you might see this being tried in other states around the country.
Yeah, that's going to be an interesting one, and I would assume where it's being tried, the leaning might be more favorable in that situation. But when you think about how that works as independent contractors, I mean, I could get my head around, maybe particularly because having lived and worked across seas in Europe and experiencing that, I can get my head around the possibility that that's got real legs.
Yeah, it was interesting because my first reaction to this was, as I read the headline, was how can they do this in Massachusetts? Because federal labor law, the National Labor Relations Act, preempts states' laws on unionization. But it's interesting because it preempts states' laws on unionization with respect to employees. It doesn't say anything. The federal law doesn't say anything about independent contractors, unionization of independent contractors. And so I don't necessarily believe that federal labor law would preempt this, but my hunch is that somebody will try to make that argument that this is not a proper effort under state law, but we'll see how it plays out.
Thank you once again for tuning in to This Week at Work. If you enjoy the show, please share it with your colleagues. Forward our invites. Share the link aimea.org/thisweekatwork, or follow or subscribe wherever you get your news and entertainment, like LinkedIn, YouTube, Spotify, Apple Podcasts. We're everywhere you are. And you can be part of the show. Send your questions and comments anytime to info@thisweek.work. We'll see you next week, 7:30 a.m. Central Time, when we discuss what's happening this week at work.